We've discussed Florida's Wrongful Death Act and Florida's wrongful death cases, and we've discussed Florida's Wrongful Death Act and how it applies to medical malpractice claims. One thing that we haven't really addressed head on is this age issue. We have discussed the age issue, your age at the time of the death of the person from medical malpractice. The statute actually addresses age, so we should probably talk about it in this video. So in order to recover as a minor child, if somebody passes away, like a parent, from a medical malpractice situation, the minor child has to be under 25 years old to be able to collect. Under 25 at the time of the death. It's also important to understand that if you're 26 or older, you don't qualify under the medical malpractice statute as a minor child for purposes of the parent collecting for the death of a child. So these ages come into play whether the child is a minor or not. If you're trying to argue the child is a survivor of a parent that has died, right? Or you're trying to argue that the child was actually a minor child for purposes of the parent's claim if the child dies from medical malpractice. I didn't make up these rules. The legislature did in Florida to try and limit the number of medical malpractice claims that were out there. So they basically said you have to be a minor child, or you have to die with minor children to have a claim, or you have to have a surviving spouse. And then they had to define who a minor child was. And my guess is this 25, 26 age limit came into as a compromise, if you will, probably between one faction that wanted probably older than that and one faction that wanted younger than that. And so they probably met in the middle at this 25, 26 time frame, age frame. So it's really important that if you have a case where there is a question about whether a minor child is either a qualified survivor under the medical malpractice wrongful death laws in Florida, or whether the parent can actually collect for a minor child's death as a result of a medical mistake. These all relate to medical malpractice limitations. Florida's wrongful death statute does not make these age distinctions in regards to cases of wrongful death that don't involve medical malpractice. So the only cases that have this age issue, where you have to analyze how old the child is for purposes of being a survivor or for purposes of a parent claiming them as a minor child in the child's death, only occur in the medical malpractice context. And they only came up as a result of some medical malpractice tort reform under when Jeb Bush was governor. Again, I don't agree with the policies, but they are the law here. So if you have questions about a Florida medical malpractice wrongful death case that involves a potential surviving child, right, or surviving spouse, you can find us on the web for that discussion at zarzaurlaw.com, or you can call us at 855-HIRE-JOE. Thank you.